judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States.
Please be seated. All right, we will begin with the first case, Caddy v. Arden, and Ms. Bateman.
May it please the court, my name is Valerie Bateman. I am here representing Dr. Madhu Kati, the plaintiff appellate in this matter. We are here today to challenge the district court's dismissal of Dr. Kati's claims of race discrimination and First Amendment retaliation arising from his denial of tenure at North Carolina State University.
Before you get in, this is a purely factual question. Are you still seeking injunctive relief, or are we simply talking about damages at this point?
No, Your Honor.
Thank you.
No, Your Honor.
You're not seeking injunctive relief?
No, Your
Which
Honor.
one is that? No.
That is.
Are you doing A and B? No is not an answer.
We are not seeking injunctive relief.
Okay. Thank you.
The district court erred in applying a heightened pleading standard demanding evidentiary proof, in addition, not just a short and plain statement of facts that Rule 8 requires, and by failing to draw reasonable inferences from the facts pled by Dr. Kati in his favor, as this court and, of course, the United States Supreme Court, Iqbal and Twombly, have required. This court's decisions in Woods and Bing.
Counsel, I'm sorry to interrupt you. Your time does not seem to be moving. I just wanted to alert our courtroom.
Oh. Okay. Thank you. And I'm sorry if I'm leaning in. I am slightly hearing impaired, and I have a little congestion. The first error the district court made was dismissing Dr. Kati's equal protection in 1981 claims because he had well-pleaded facts which allowed inferences, multiple well-pleaded facts involving multiple situations, which allowed the court to draw inferences that should have been in favor of Dr. Kati, but in fact were drawn against him.
Can I ask just a broader conceptual question? We often see these cases brought under, like Title VII or various statutory claims. You've obviously brought this as a 1983 suit implicating the Equal Protection Clause, just to take the 1983 claim. Can you tell me a little bit like how you think that makes this different from a Title VII case? And in particular, what sort of strikes me is the argument that your colleague made in the response brief, which I think is correct, is that it's defendant specific, so that you have to plead facts with respect to each specific defendant. And so we got to think about Goodwin separate from each person. And your reply brief responds to that by just saying NC State does this and NC State does that and NC State did this other thing. Do you, so sort of non-responsive to the question that it's got to be defendant specific, do you agree that it is defendant specific, that we have to show that you've pled a cause of action with respect to each defendant and analyze each defendant distinctly? Or do you disagree with the premise?
No, I totally agree with that premise because it flows from exactly the holding in Iqbal. In Iqbal, everybody else underneath Mueller and Ashcroft were left in the complaint because there were sufficient factual allegations that the court felt like showed they either knew or should have known about the conditions of confinement. What happened in Iqbal, though, was that the plaintiff failed to plead any personal involvement by Ashcroft and Mueller in the conditions of confinement in the real heart of the adverse actions that were being pled in that case. That case is different from this case in that Dr. Cotty's tenure package, not only did Dr. Gower, of course, Dr. Goodwin had involvement in it because she was on the committee.
But it's not just involvement, right? So your point is they have to be involved. That's fine. But in fact, we have to look at Dr. Goodwin, just as an example, and we have to say, have you met plausible allegations met, every element of the offense, looking at her in isolation, right? And so we have to look at who are the similarly situated individuals that she treated differently than your client. Not whether NC State treated people differently, but what precisely did Dr. Floyd do with respect to similarly situated individuals? It's defendant specific. You can't there's no respondent superior liability. This isn't a question about what NC State did or didn't do, but instead it's a question of individual defendant by individual defendant. I mean, I just want to make sure you agree with the framework, and then give me your best story for who you think you've plausibly alleged facts for.
Yes, Your Honor. I understand. I agree with the framework. I understand it's defendant by defendant. What I will say is that what the courts have said, even when there are multiple defendants, is that the plausible evidence can be looked at as a whole. But I will say with regard to Dr. Goodwin.
Wait, I'm sorry. What case has said that we don't have to look at it defendant by defendant, but we can look at it as a whole?
I'm not saying you don't look. I'm not saying you don't look at it defendant by defendant. Let me just accept that premise and move forward from there. The cases I'm talking about say when you're looking at the whole complaint, you look and see if there's evidence of all these things, even if the evidence of a specific point would not
If we
be
start
sufficient.
looking at it in the whole complaint, I mean, I think Judge Richardson's point is a good one because a lot of these defendants were not even involved in this case at all. But if we look at it as a whole complaint, I have concerns about courts wading into the tenure process. You submit this chart, but the chart has all these numbers and everything, but the quantity doesn't tell me anything about the quality. And in a tenure case, it might be that one individual, that one seminal article is worth 10 that are not that good, and so I did not find the chart with just the numbers particularly helpful because that's not exactly the way that the tenure process always works. It's a qualitative process. It's a qualitative process. It's not a quantitative process in the way that you seem to want to posit it with respect to comparators. And having the courts involved in the tenure process makes me unduly involved, makes me nervous because I don't understand a lot of these areas. If you ask me to evaluate a tenure application for physics or economics or the Chinese language or what have you, I don't really have the background to resolve those kinds of cases, but I think...
Don't undersell your abilities. I think you could do the Chinese one.
That's... I don't know how to take that. But all I'm saying is I think those academicians and faculty members who are engaged in this process bring to it a familiarity with the subject matter that I don't have, and I can get.
Yeah.
experts to help me, but that still doesn't, that.
I understand, Your Honor.
That's not going to help me that much.
Luckily, NC State's already made that decision for you because the next year, he got tenure. So he is tenured now. They have evaluated his application. What we're talking about is the year that Dr. Goodwin participated, and Dr. Goodwin's articulations of...
Why should I assume they got it right the second time?
Well, that's
why
Brad.
why do I have any more reason to think that they got it right the second time versus the first time?
Well, the
right? They might have
evidence
felt pressure because they were worried about a lawsuit, right? They might have decided, I got no idea why they
Yeah.
did it.
And I don't either, Your Honor, but what I will say
But you
is-
agree I can't assume they got it right the second time any more than I can figure out whether they got it right the first time.
Well, you can assume they changed their mind, and the reason they changed their mind you can infer from that Dr. Goodwin was not involved. And Dr. Goodwin was known let me just speak to Dr. Arden and Dr. Floyd, because they seem to be the most remote, but they are not. When the tenure package goes through review, the entire tenure package goes, and that
No,
includes
I don't want to leave Judge Richardson's point here about which is right, the first or the second. And these lawsuits are going to lead to tenure inflation, the same way that we now have grade inflation in schools. And the point is, these tenure decisions will be made with the idea that we want to avoid having the plaintiff come into court, and the way that we avoid having the plaintiff come into court is awarding the plaintiff tenure. And so you lead, this whole stream of litigation leads to tenure inflation that's going to parallel grade inflation. And I'm just trying to explain to you why I'm a little cautious about wading into this whole process. It's qualitative, it's not quantitative. I'm working from a deficit of expertise and a deficit of knowledge, and I don't want to see external pressures put on the process such that it becomes less merit-based and the judiciary essentially installs themselves as guardians of the tenure process and takes it away from individual faculties involved. There are a whole lot of caution flags for me, whether one looks at the suit individually, which I think is an entirely valid point, or whether one looks at it globally, which I think is also an entirely valid perspective.
Your Honor, I would have two things to say to that. One is that if there's a gatekeeping function to be done, it should be at the summary judgment stage, not the motion to dismiss stage, because all the inferences at this point in the litigation should be drawn in favor of Dr. Cotty. And that means the chart, and that means Dr. Goodwin's participation, and that means the fact that Dr. Arden and Dr.
Well, I
Floyd
understand that,
reviewed the
but-
appeal,
but-
and the fact that the...
Excuse me one second, but, the people are, we do have to recognize that there are cases like Iqbal and Twombly that do put some, in their term plausibility, they do put some burden on the initial pleading that was not there before under the Gibson versus Conley view of Federal Rule 8. And it's a dramatically different situation, or let's just say it's a different situation.
In this case, Your Honor, though, there were violations of the tenure process. And if the tenure process itself is not followed, that's not the case in every single tenure case. In this case, the process...
Were any of these folks involved in the tenure decision for Delborn?
Your Honor, I don't know, but comparator evidence...
Okay, so just help me understand, how then is Delborn even plausibly a similarly situated individual? If we have no allegation that any of these folks were involved, we can't use him as a comparator at all, right? And I think I could do the same thing running down the whole list, right?
Well, the comparator evidence is evaluated at summary judgment. It's not evaluated on a motion to dismiss. This court has held
Not
that
on equal
repeatedly.
protection claim. On an equal protection argument, you have to allege a similarly situated comparator.
You have to have similarly situated comparators, but the inferences at the motion to dismiss stage are drawn in favor of the plaintiff.
Excuse me, the problem I have is the kind of inferences that you're drawing, which is that any adverse decision, you just say, well, it must be a matter of race. I mean, and that strikes me as speculation and not plausibility. When you say it can only be explained by race, well, that seems to me a real jump to say that a decision like that can only be explained by race. You have to explain why that's true.
We're not saying at this stage of the pleading that it can only be explained by race. We're saying there are facts in this case that allow a plausible inference.
I don't see them.
You don't see them?
No, I don't.
Oh, my goodness.
Because the main fact you talked about, all of these different people who gave rather detailed reasons for, some of them were uninvolved and others gave rather detailed reasons for why they arrived at an adverse decision.
Dr. Cotty pled facts about how he was misled about the awarding of tenure to people when they come into the university.
Who hired Dr. Caddy?
I'm sorry?
Who hired him? Who made that representation?
Dr. Gower made that representation.
Is it in the complaint who hired Dr. Caddy?
Yes, Dr. Gower hired him.
And what paragraph am I looking for that?
In 12, it starts at 12, and then there's 88 and 87. This is on Joint Appendix 13 is Dr. Gower is the head of the department.
Wait, I'm sorry. Are you on JA what?
JA 77, JA 78.
And it says, who made the decision to hire who was the decision maker that hired Caddy? I mean, I'm going to it right now, but what you're representing to me is that when I get there, that the person who made the decision is identified on JA 77. Which paragraph am I looking at?
Dr. Cuddy came in 2016. You can draw the inference, since Dr. Gower was the head of the department at that time, that he was the person who...
Why would I plausibly draw that inference? Because that's not who grants tenure. In most of places, the department head is not the person that hires. It's the provost or the president. Why in the world would I draw that inference? Like, tell me, I'm happy to draw all reasonable inferences, but like, why possibly would I draw that inference?
Because Dr. Cuddy pled it, and because you have to draw...
Where did he plead it is what I'm asking you. And you said JA 77, and it doesn't say that.
No, it says that, but I will tell you that Dr. Cuddy also pleads specifically in paragraphs 104 and 105, and that's on JA 97, that prior to Dr. Cuddy's coming to NCSU, he was a tenured professor, and he left that position to come to state as a non-tenured professor only because he was told by Dr. Gower during negotiations that neither the department nor the college offered tenured appointments. After he agreed to come as untenured, he learned that the department did in fact hire at least 3 individuals with tenure.
Excuse me, counsel. Thank you.
Judge Wilkinson, could I ask a question about the First Amendment claim?
You certainly may.
I want to understand the First Amendment claim. You presumably don't take issue with the proposition that it violates the First Amendment to say, I think you're a bad teacher, I don't want to tenure you?
No, what happened in this case is we would argue...
No, but, no, I understand. I know your claim is not that case, but I'm trying to understand. So if we all posit that a university has to be able to say, I don't want to hire you because I think you're a bad teacher, I don't want to tenure you, I think you're a bad teacher, and the person responds, but actually I think I'm a great teacher, the university can say, I respectfully disagree, I don't think you're a good teacher. So what's the difference between that, if we posit that they can do that? What's the difference between that and what you're alleging here? Because based on your complaint, I don't really understand what these unconventional teaching methods are and why that's a First Amendment problem.
Well, it's like, it's not exactly similar, but it's very similar to Garcetti, where you had somebody doing their job who saw affidavit that had misleading or false information. and
That's a
for-
whistleblower situation. This is about someone who like just wants to teach the way he wants to teach, and his bosses don't want him to teach that way.
There's no independent evidence that he's not a good teacher. They don't
They don't
like
think
how he teaches.
I don't
There's
thi-
no evidence that he is not effective as a teacher.
Why don't they get to decide that without the First Amendment countermanding their view about whether he's a good teacher or not?
They might get to decide that at summary judgment, but on the motion
okay.
to dismiss, they have to take his facts in the light most favorable to him.
Thank you, Patricia.
This clock is going up. Am I over
Yes,
my
yeah.
time?
All right, thank you very much.
Thank you.
Smith, we're pleased to hear from you.
Good morning. May it please the court. My name is Lindsay Smith. I'm a Special Deputy Attorney General with the North Carolina Department of Justice. I'm here with my colleague, Jeremy Lindsley, and we represent the defendants' appellees in this appeal. So as the allegations in his amended complaint reveal, Dr. Cotty's colleagues were concerned about his performance in a number of areas. And those concerns resulted in the denial of his original application for tenure. They focused on a failure to appropriately mentor students and to fulfill his obligations in a co-taught course, as well as mediocre student reviews of his courses. However,
So why'd you change your mind and grant him tenure?
there's no evidence there are no allegations in the record, Judge Heitens.
You're great.
About why.
It would be a serious promotion.
It would.
and I'm not entitled to it.
No PhD.
But there are no allegations in the record as to why the tenure decision was different the second time around. I will say that Dr. Cotty's original application for tenure was made in June of 2019. I believe I don't know if there's allegations about when his second application was made, but he was granted tenure in I believe, April of 2023. And so there's a significant time difference between the two. But he was offered to reapply for tenure. He did. As I stated, he was granted tenure in April of 2023, and he is still a tenured faculty member at NC State to this day. But as we've already discussed, this case involves a straightforward analysis of Dr. Cotty's allegations to determine whether he pled facts sufficient to infer that the denial of his original application for tenure was the result of race discrimination or in retaliation for his First Amendment rights.
So just a framing question. Do you agree if, and I know that you are not going to agree that he actually did this, so this is a counterfactual from your perspective, if he plausibly alleged that he was treated differently from a similarly situated white comparator, that would raise an inference of race discrimination, for purposes of the plausibility standard?
For purposes of the plausibility standard, I think I have to agree with that, Your Honor.
I think so too.
I think I have to agree with that. I mean, I do.
But defendant specific, right? You should have to show a white comparator that Dr. Goodwin treated differently, not that NC State treated differently, right?
Correct, Your Honor. And I would say that's specific to the equal protection claim. And the reason I say, Judge Heitens, that I think I would have to agree with that, the equal protection claim, you have to allege that the the plaintiff was treated differently from others with whom he was similarly situated, and that the treatment was the result of intentional discrimination, right? And so
Well, but hold on. He's got to prove that in order to win
I
his...
apologize. He has to allege that. I misspoke. So he has to allege that he was treated differently from others from whom he was similarly situated.
In this context, it's very difficult to determine who is similarly situated to others. We have this chart with these numbers and everything, but that doesn't really do anything for me because it doesn't go into the qualitative aspect of it. And it's very hard to, in this kind of process, to know who is similarly situated to who else, because each tenure decision is very individualized, and each tenure decision rests on a number of subjective and objective judgments having to do with teaching ability and having to do with scholarship and having to do with administrative contributions and a whole lot of things. And there's room for difference of opinion on that. And they're very individualized situations. And it just seems to me the context and the particular setting it makes similarly situated a very treacherous and sort of tricky undertaking. Do you see what I'm saying?
Absolutely, Your Honor, and I would agree with that. I mean, I don't
Really?
think...
There's a tenure exception to the Equal Protection Clause and to Title VI and to Title IX. You can just say tenure's super hard, so you can't sue for equal protection violations for tenure?
So
That's you agree with?
I would not agree with
I didn't
that.
think you did.
I would not. So I think I would agree with Judge Wilkinson that he's correct that it is difficult in the tenure context to allege a similarly situated comparator. I don't think it's impossible, Your Honor, but what I would say is that here, Dr. Cady hasn't even come close, right? I mean, the comparators that he points to...
I should make it clear that I'm not arguing for a categorical tenure exception to anything. I'm just trying to state more modestly that there are difficulties that are inherent in this process. You can overcome those, but I don't think the pleading here plausibly does. That's the problem that I have. But I'm not a categorical person, and I'm just having problems with the particular case that's being pled and the difficulties involved with that, and the fact that all of the individuals fall into one of two groups. One of the groups involves people that were not involved in the process at all, or were only very marginally involved. And the other group of people like M.S. Goodwin and others who gave detailed reasons for their appraisals and had actually co-taught a course with the individual or had been involved with the individual in some way that gave them a basis for appraisal. And so you have these, in this particular case, there are all kinds of parties brought in that have nothing or little to do with the process. And the people that did have something to do with the process spelled out their reasons in some detail. And they seem to go to the heart of how you evaluate the application. But I'm just, I would never argue for any kind of categorical exception. All I'm suggesting is that as an individual case here, I'm just not sure the plausibility standard is met, but it's a very individualized kind of situation. And I just think in this particular case, I'm just not certain that the plausibility standard has been satisfied. And maybe come down the road, different case, where it's much more arbitrary or what have you, and be altogether different. But not here. I mean, Miss Goodwin's comments were, she had both a good place from which to evaluate it, and her comments went right to the heart of the assessment.
That's correct. And I would say with respect to the specific allegations regarding the individual defendants, I think to Judge Richardson's earlier point, specifically for Drs. Goodwin and for Gower, I mean, I think the place that you really only get the any allegations that there were racial motivation. I mean, I think the district court was correct to say that there's a lot in this complaint about the process and the unfairness of the process, but there is conspicuously little regarding race. So if you look at paragraph 190 of the complaint, and it's at JA 119, and that's really where we get, I think it's one of the only references to the racial motivation here. Dr. Goodwin's animosity seemed to arise from her stereotypical view of men of Dr. Cotty's race and ethnicity, and the enabling of Dr. Goodwin by Dr. Gower.
So let's posit that I agree that the allegations about Goodwin's specific bias seem to me to have real Twombly-Iqbal problems, because just because you say over and over again she disliked me because of race doesn't mean that you've plausibly alleged that she disliked me based on race. Let's posit that I have a lot of sympathy for that. I'll just tell you what my biggest hesitation is. It's paragraph 213, and it's the one where we do a detailed comparison between Dr. Cotty and Delburn. And I take the point. You may well have great arguments. There may well be at summary judgment or at the merits, there may be great arguments for why these two people are not actually similar. Judge Wilkinson makes the point about the one amazing article versus the 10 mediocre ones. And that may be true, and you might win at summary judgment, you might win at trial. But looking at this chart, and I'll also further posit, I'm not sure this would get them there with regard to all the defendants. I'd have to think about which defendants it gets them there with. But this, at least to me, looks pretty prima facie plausible of an allegation that Dr. Cotty and Dr. Delburn are similarly situated, or at least if we say this isn't enough to allege you're similarly situated to survive a 12b6 motion, we are making a very high standard for pleading similarly situated at the motion to dismiss stage. So walk me through. What's your best response to paragraph 213 of the complaint?
So there's a couple of points I would make to that, Judge Heitens. I think the first is, I think to a point that was made earlier, there are no allegations in the complaint about who was on Dr. Delborn's tenure review committee, right? So there's no allegations that any of the individual defendants were involved in his tenure review committee, and so there's no allegation, there's no basis from which the court, this court or the district court, could infer that the individual defendants treated Dr. Delborn differently because of his race.
And is this partly a problem? I'm just trying to also figure out, because again, I had the same reaction to Judge Richardson when I picked up this case. I was like, this is a Title VII case. I don't understand why this is a 1981, 1983. This is like the most straightforward. I don't mean who wins, who loses, but I mean, I just look at the allegations of like the bad thing that happened to me and who did it. He was like, this is a Title VII case. So is that a 1983, 1981 specific? Because if it was Title VII, the university would be the employer, that'd be the defendant, right?
Correct.
That would be the defendant if this was a Title VII case.
That is correct, Your Honor.
And would this all necessarily play out the same thing of like, because then could you say that all of these people were acting on behalf of the university and all? I guess what I'm saying is we're going like who's on what committee. Is that a 1983 specific thing, or would that apply in a Title VII case too?
So I think it would be less applicable in a Title VII case, Your Honor, because it's the 1983. I mean, the 1983 claims are brought individually against the defendant.
NC State is not the defendant in this case.
That is-
NC State is not being sued here.
That is correct, Your Honor. These are individual, there were official capacity claims in this case. Those were dismissed by the district court and have not been appealed by Dr. Cotty. So the only claims that are at issue before this court are the individual capacity
Okay,
claims.
thank you. I interrupted you. You had a couple of points on that paragraph.
No, that's okay. So that was my first point, was because of those individual defendants. I would also say that the allegations in the complaint, I think, are insufficient to show that he is not similarly situated in other aspects. I mean, for example, the chart on the previous page on JA 124.
I'm not talking about those other people or that chart. I'm talking about the Delburn allegations.
I understand, Your Honor. So on that chart, Dr. Delborn, it's indicated that he was hired in 2013. Dr. Cotty was hired in 2016. There's nothing in the complaint.
So 3 years as a matter of law is long enough to prevent people from being similarly situated?
No, Your Honor. I guess what I'm trying to say is there's nothing in the complaint to.
Because I would agree with, look, if Delburn was hired in 1975 or 1989, I think we could say that does not plausibly allege you're similarly situated to someone hired in 2016. But I'm a little reluctant to say that 2013 and 2016 are far enough that it's not plausible.
I think the point I'm trying to make, Your Honor, is that there's nothing in the complaint to indicate when Dr. Delborn was granted tenure. And so there's nothing to indicate how long.
So I thought your answer to that, to Judge Hyten's question, was going to be totally different. And so help me understand why the answer to this isn't, this is a comparison of the writing quality, the publishing quality. But nobody in this process has suggested that Cotty didn't get tenure because he wasn't a prolific publisher. They said he couldn't teach and that he had interpersonal problems. And so you've got to have a comparison of like similarly situated in the similar ways that like affected him. And so the fact that, they were equally good writers, whether that's true or not, I'm not sure that this actually shows it, but I take Judge Hyden's point to be maybe plausible, maybe. But what it doesn't do is actually address the similarity in the relevant respect, which is nobody said that he doesn't get tenure because he's not sufficiently, or the primary reason is not, he's like insufficiently prolific, right? That he's not publishing enough papers, right? Is that he's a bad teacher and that he's got interpersonal problems. Like that, and so if you had a column that, or maybe I guess it's rows at the bottom that said, Delborn also like noted bad teacher, right? They're both noted as bad teachers, and they're both noted as having interpersonal problems. Well, then it would be a reasonable comparison. But you don't get to just pick writing and say they're similarly situated as writers and suggest that that means they're similarly situated for equal protection analysis by ignoring the very thing that caused Dr. Cotty to be denied tenure.
That's exactly right, Your Honor. I mean, and that was going to be my third point, is that, and I would say this court and has repeatedly acknowledged, especially when you have a case where we're talking about a performance case and we're trying, the plaintiff is attempting to allege comparators, that you're exactly right, that the plaintiff, in order to allege a similarly situated comparator, has to show that that comparator was situated with respect to their conduct and with respect to their supervisors in terms of the...
One question in addition here, there's a plausibility standard, and what repeatedly comes up is, well, this can only be explained by race. Well, I mean, that in itself, those kinds of statements are conclusory statements that may have been acceptable under the old Rule 8, but are not, you can't plead the conclusion without giving some reasons for the conclusion. And when you say, well, the difference in outcomes can only be explained by this, can only be explained by that, well, the question is, why is that the explanation? And you can't just, and what's been done here is to plead a conclusion without saying why the conclusion is a justified one. And that can't be plausible to just say this can only be explained in this way. You have to go into it, at least somewhat. And I think that my fine colleague says, of course, there is a difference in 12b-6 and summary judgment, but 12b-6 requires something. I mean, plausibility means something. It doesn't mean a whole lot. And I don't want to raise the bar, but it does require something.
Yeah, I agree completely, Your Honor. I mean, I think that's the main concern that we have raised about these allegations about the individual defendants. And I would point this court to its recent decision in the Nadindla case. We cited that in our brief.
I don't think any one of us wants to be judged by a decision we make, and then somebody says, well, your motive can only be, or this can only be explained by a bad motive. You had a bad motive, and this can only be explained by this terrible motive. Well, my response would be, well, why do you say that? You're simply jumping to a conclusion and depriving me of any presumption of innocence or depriving me of any presumption of legitimacy. And you say, no, what you did can only be explained by this nefarious, malicious motive that you had. Well, why?
That's correct, Your Honor. And I think the Nadindla case is directly on point. And what this court held there was a physician who had been revoked privileges to, hospital privileges to Wake Med. And in her complaint, this is another 12b-6 dismissal that was challenged on appeal. And in her complaint, she made similar, very generalized allegations about the way that that Wake Med had treated other white physicians, but didn't allege any specific facts to underlie those conclusory or speculative statements.
Can I ask you about the First Amendment claim? Are you aware of any decision other than the Sixth Circuit's Merriweather decision that talks about like whether teaching methods are protected by the First Amendment? This seems like a really potentially tricky, hard question.
It is a tricky, hard question, and I have not recently looked at the appellate decisions. I mean, there are cases. I would say there's cases out of there's a Ninth
Because these
Circuit
academic
case.
freedom cases, right, to me, tended to be more like viewpoint or content discrimination, like, you know, saying actually, you know, Marx had some good ideas, or actually, you know, things like that, and, you know, criticizing the war in Vietnam in a class about history, political science. They don't tend to be cases about the way that I teach is the First Amendment claim.
That's correct, Your Honor. I mean, Merriweather, I think, is sort of the closest, but it's about the content and not about the method for teaching. And I think that it kind of goes to, and I think Your Honor has alluded to this already, this is the main problem with the First Amendment claim, is that what we would say is, you know, if the way that you teach is, and being sort of actions taken based on the way that you teach is a First Amendment problem, then there is no way that any university could ever provide feedback to a professor or take any action against a professor based on poor teaching. And I think that's certainly not where this court wants to end up. I mean, I think we've also made the argument, you know, that it's certainly not a specific enough allegation of a specific enough statement or conduct to even get into the First Amendment analysis. Now, you know, I think that there are the First Amendment analysis has multiple other steps,
Sure.
and we've argued in our brief that the plaintiff has failed to meet any of those steps. And in fact, on their reply brief, they don't even mention the balancing test. They don't even mention the but-for causation standard. And I think for that alone, they've conceded those points.
Thank you.
You're welcome, Your Honor.
Can I ask one other question? Of course. Do you mind? One of the things that I just am curious about, maybe, again, sort of like Judge Hyde's question, might not end up being relevant to the opinion here. But your colleague on the other side alleges that Indian men are chauvinistic and disdainful of women as a stereotype. I confess I'm not like all that up on all the stereotypes, but what do we do with that? I mean, it's just like a bald assertion that Indian men are stereotypically chauvinistic and disdainful of women. And she's relying on that to say that, you know, must be why Dr. Goodwin, who I presume in this context is a woman, therefore, like, is against him. You know, we have some stereotype cases where we seem to sort of like accept stereotypes just being alleged. How would you have us think about, you know, such a, I don't, it's a sort of a new one to me, but like, what should we do to evaluate an allegation that there's a stereotype that, at least to me, is not like widely known or accepted?
So I think, Your Honor, I think the question, maybe a better way to phrase the question is, what do we do about the allegation that Dr. Goodwin held such a stereotype?
Well, but they don't actually allege that, so there's no allegation, or maybe her stereotype, right? So maybe it is that she held that view?
That's the way I read the complaint, Your Honor, is that the allegation is that she held this stereotypical view. And so I guess, I don't know that this court needs to even...
But if it's not, okay.
I mean, I guess what I would say is I don't know that this court needs to evaluate the allegation that there is a stereotype about Indian men as chauvinistic and disdainful of women. I think the allegation, at least the way I've read it, is the allegation is that Dr. Goodwin held this particular view, right? That Dr.
But it's different than just saying she held this view and saying that, like, this view is a common, I mean, in fact, what she's saying is that she held this view and it is a common one, which in some sense, I take the reason it's pled that way is to lend credence to the, you know, sense that this must be her view.
Yeah, I mean, I think what I would say, Your Honor, and I realize my
Yeah,
time
no.
has run out, but I'm happy to
Yeah,
respond briefly.
please.
I think what I would say is that regardless of how we view that, there's no other allegation in the complaint about such a stereotype. This is the only allegation in the complaint, and as this court, as Iqbal has held, threadbare recitals supported by mere conclusory statements just simply don't suffice to satisfy the 12b6 standard.
Well, and the point my colleague raises could be, it's so broad, it could be used in any discrimination case where the plaintiff and the defendant are of different genders or different ethnicities or whatever. You could say that just, well, the person of this ethnicity has a stereotypically prejudiced view of all people in a different race or ethnicity, and so you could, the stereotype would be just there to pull out of the drawer for any case in which the racial or ethnic background was different. I mean, and if that were to do the trick in terms of plausibility, we would be in a very difficult position indeed.
Yes, I agree, Your Honor.
I mean, there's no limiting principle there.
I agree, Your Honor. And that's what we would say, that it just simply doesn't meet the plausibility standard. My time has elapsed. I'm happy to sit down for the reasons that we.
Just hold on for 1 second.
Yes, sir.
I'm good. I'm very good. Thank you.
I'm good.
You okay? All right.
Thank you, Your Honor. We would ask that this court affirm the district court's opinion.
We thank you, and Ms. Bateman, you have time for rebuttal.
Your Honors, there is no question but that there was a policy that said that the committee members have a responsibility to recuse themselves from voting if there's an actual or appearance of a personal or professional conflict of interest. So even if we assume that we don't know why Dr. Goodwin was biased against Dr. Cotty, she should not have participated in that.
Maybe as a matter of NC state policy, but I can't possibly imagine why the Equal Protection Clause requires that.
No, Your Honor, I'm just, I guess.
I'm trying to understand. So, okay, so let's pause it. I think the complaint does a very good job of plausibly alleging something, which is that Dr. Goodwin really, really, really did not like the plaintiff. I think it alleges that pretty well, or at least plausibly alleges that pretty well. But okay, fine, and maybe based on the university policy, based on that, she should have recused. Maybe. I'm granting you lots of
yeah.
not good. I'm granting you lots of assumptions here. But even let me spot you for the sake of this question. All of that, I don't understand what that has to do with whether this violates the Equal Protection Clause.
Well,
And maybe it violated university policy. Maybe. So help me. Let's assume, and I'm not even saying I agree with you on all of the premises here, but maybe how does you started your rebuttal by saying she should have recused, and then I say, okay, why does that violate the Equal Protection Clause that she didn't?
because it's one of many examples of how Dr. Cotty was treated both in violation of policies and.
But this isn't a claim for violation of policies.
Well, the evidence in a 1983 case and the evidence in a Title VII case are the same except for tagging individual defendants. And you can still use the amalgamation of the evidence of pretext in the complaint to establish a case that gets you past a motion to dismiss. And we would submit in this case, that's what Dr. Cotty did. He has 200 paragraphs of allegations from which an inference of pretext can be drawn.
I go back to the initial premise. Why in the world should Dr. Goodwin have recused? I don't understand that. In these tenure decisions, this individual, Dr. Goodwin, would be the very one whom a tenure committee, whose views the tenure committee would be soliciting. And Dr. Goodwin had comments that were were highly relevant to the decision, which she criticized for failure to teach an introductory course and failure to mentor graduate students, and that there was, the students in the course were jumping ship to Florida State and all the rest, and
Dr. Cotty's complaint, though, alleges
well,
that none of those were true.
all I'm saying is that Dr. Goodwin has very highly relevant information, and she should be involved in the tenure process.
It might not be the policy you or I would make, Your Honor, but the North Carolina State's policy says if she has a personal or professional, actual or appearance of conflict of interest, and clearly her statements of bias made to Karen Cooper and Dr. Gower were evidence of
Wait, statements of bias? What were the statements of bias?
Her stating to Dr. Cotty that she could not work with him, the criticism of him over an issue that he had consulted with Dr. Gower.
But I could say, for example, that there's a given lawyer who I think makes ridiculous arguments and in a way that I do not like. That doesn't make a conflict of interest. They just might be making ridiculous arguments, right? Like, that's not a conflict, right? So if I have in a professional setting a view about somebody's competence, right, that does not create a conflict of interest. I have a conflict of interest if I have some merits-based problem. But I guess I'm just not following when he says, I can't work with this person because they have interpersonal problems. That's not a conflict. That's just like a recognition that this person is not a competent professor.
And if you keep that to yourself and you don't tell it to other people and you're not trying to influence other people to disregard that lawyer's conduct, then perhaps that would just be an assessment of that
But your view is it becomes a conflict when I go back and I say to my colleagues, that argument was ridiculous.
Yes, well, Your Honor, doesn't become a conflict, it becomes the appearance of a conflict. You don't have to say the argument's ridiculous, but if you say the person is ridiculous, and that's what Dr. Goodwin was doing, is she was attacking the person to such an extent that her own colleague tried to talk her out of serving on his tenure panel because she knew it created the appearance of a conflict of interest.
Well, you're getting too close to the proposition that any negative comment about somebody during the course of a tenure evaluation is evidence of bias. That you can't make a negative statement about anybody without somehow being accused of bias, and that deprives the tenure process of a full flow of information.
Even one of the individuals who was on the tenure committee with Dr. Goodwin said that her behavior during the tenure deliberations made it very difficult for them to write a balanced report. Other people recognized that she went beyond what just disagreeing with the quality or quantity of his research teaching service was, but that she actively tried to poison it. The point, though, is here, Your Honor, he's got plenty of facts in his complaint that allow an inference, a plausible inference of discrimination and retaliation. And on a motion to dismiss, it's not this court's job to say whether he will or not be able to prove that at trial or at summary judgment. The district court should have said there's enough here to get us over the line from plausibility, from speculation to plausibility. You don't need to fill in any blanks here. This is clearly a case. Oh, I'm sorry, Your Honor.
The problem here is that I know you don't like the outcome of the initial decision, but the hard part is linking that up in some way to racial bias, because there may have been a personality conflict between Dr. Goodwin and whoever, and I don't know. And in any tenure decision, some people are vigorously engaged and don't believe tenure should be awarded, and they feel that with a real sense of conviction. But I don't understand how all that gets related to race as opposed to a personality conflict or opposed to a difference of opinion. Every difference of opinion should not be open to the suggestion made in the complaint, well, this can only be explained as a matter of race. No, that's not right. It can be explained by a difference of opinion, a personality conflict, a difference over teaching methodology, or a million different things. And you've got to clear that bar. You've got to relate this to racial considerations in a way that was not done here.
I absolutely agree, Your Honor. You cannot just say, I am Indian and I didn't get tenure. That's not what Dr. Cotty's saying here. He's saying, I am Indian, I didn't get tenure. There were people who tanked my tenure bid, and there's lots of violations of policy from which you could draw inferences of pretext.
Okay.
Thank you.
Thank you, Greg. Let me ask my colleagues, because if they have further questions.
I'm good.
You okay?
Yes,
You
I'm
okay?
okay.
Okay.
Thank
Thank you
you.
very much. We'll come down and greet counsel, and then we will move right into our next case. Mr. Brown?
Good morning, Your Honors. May it please the court. I'm Justin Brown on behalf of James Flood. And what we're asking the court to do is fairly simple. We're asking the court to remand this case to the district court to conduct an evidentiary hearing. I'd like to begin by explaining the ineffective assistance of counsel claim. It's at the center of this case. And then after doing that, I'd like to go into some of the factual disputes that pervade this case and that necessitate a hearing. So the claim presented by Flood in his 2255, dating back to 2011, was that trial counsel was ineffective for how it conducted or failed to conduct plea discussions in the pretrial phase. Obtaining a plea in this case should have been an obvious first step that any defense attorney would have taken, yet counsel completely abdicated their role as defense counsel when they failed to do this.
What? Man, I want to hear from you, but how can you say that? We know that defense counsel talked to the prosecution about a plea. So, you might say that's not enough, but you can't say completely abdicated, right? Because they talked to them and said, what about a plea? And they said it'd require a proffer first?
Well,
is there a dispute that conversation took place?
well, the government denies that it took place. So to that extent, there is a dispute. But I think for purposes of today, we have to assume that it did take place. But that took place during jury selection.
All I'm asking you is, you said completely abdicated, right? And it just doesn't seem consistent, right? Totally fine to say, didn't do enough, right? Wasn't sufficiently engaged, should have done it sooner, should have done it later. I don't know what you want to say. But it's just hard when you start off by saying completely abdicated, when that doesn't seem to match up with what the record shows
Well,
us.
Your Honor, I am going to push back on that a
Okay.
little bit because that conversation took place technically during trial. So we're talking about the pre-trial phase.
During jury selection.
Correct.
Yeah.
Correct. We're talking about the pre-trial phase where a singular objective of those lawyers should have been to find a way to plead this case out. And when there was a complete failure to do that, right, there wasn't defense counsel did not approach the government a single time. They did nothing at all to try to obtain a plea. And this case was screaming out for a plea agreement.
No, it wasn't screaming out for a plea agreement. There would be a natural reluctance when you looked at the conduct here, the kidnapping and resulting in death, which had a mandatory life sentence. There could be plenty of reasons that the government would have been entirely resistant to having the case plead out. It seems to me plausible that this isn't the case that you would cut someone a break. I mean, what the allegations here are very, very serious.
Your Honor, I
And that
agree.
only begins to state the problems because they didn't think that this individual, normally these pleas are extended in this kind of case for an offer of cooperation in some way, shape, or form, but this person was not viewed as someone who would provide reliable or persuasive testimony before a jury in any case, because he would have been open to impeachment on the grounds that he was a congenital liar. And so the problem is you're not holding any cards. You don't have a plausibly trustworthy witness to offer as part of a cooperation deal.
Well, Your Honor, if that were the case, and I ask this question rhetorically, why is it that it was the government, it was the prosecutor who approached defense counsel to initiate plea talks? So therefore, it's a logical inference from that the government must have had some interest in Mr. Flood.
As a cooperator.
There's a dispute over that as well.
What is the dispute about that?
Mr.
What is the evidence that the government was willing, I mean, I know we're moving around a little bit, but what is the evidence that's in dispute that the government was willing to think about any plea that resulted in time less than life? Because if it's not less than life, the plea doesn't help, right?
Right.
So they might have been willing to let him plead straight up, but you can't bring this claim here. That they would have thought about a plea less than life for someone under these circumstances, and for Mr. Flood in particular, that didn't involve cooperation.
And Your Honor, I may be splitting hairs a little bit here, but in Mr. Lawler's affidavit, he talks about proffering. And then the government's version is similar, but a little bit different when they talk about full-blown cooperation, a cooperation agreement.
You've done enough of this to know that the first step to cooperate is to proffer, right? Like that is not like those are totally different things. We can't possibly think about those the same way. We've both done this enough to know you don't have cooperation without a proffer first, because we have to evaluate whether the person's being honest and truthful.
That's correct, Your Honor. You don't have cooperation without a proffer first, but there are times when there's a proffer, a truthful proffer, but no cooperation. And again, I don't want to get bogged down on this because it's splitting hairs to some degree, but the fact is, it was the government that reached out to defense counsel. And defense counsel, not only did they not engage, I mean, they clearly rebuffed any efforts that were made by Ms. Wilkinson to initiate plea discussions, but they didn't even convey that to their client, and they didn't even bring him into the process. And
There's a big element of hindsight into this. You know, the individual was convicted, and he sits there in prison, and he says, well, this should have been pled. I should have pled and everything. But it's hard for me to see that the criminal justice system misfired in this situation. They have a jury trial. It was an 11-day trial. He was convicted of kidnapping, resulted in death, and obviously this was an outcome that was not pleasing to the individual involved. So what so often happens is people sit in jail and they think about it a little bit, and then they say, well, doggone it, this thing, I should have pled. And that's just a situation of buyer's remorse. And we find that all the time in these plea cases, that people having second thoughts because they disliked a particular adverse outcome. And they say, oh, I could have gotten a better deal if I'd gone a different route. And so we blame it on the lawyer. But that, I don't see that here. I wonder what the standard of review is here. And this is
Your Honor,
question of,
if I may, it's an abuse of discretion standard for denying the evidentiary hearing. But to address your point, I would suggest that this is just the opposite of what you have described, because this is an extraordinary happening here where there's a case as serious as this, and where there are no plea discussions at all. I mean, we all know.
That's not extraordinary at all. I mean, I know it's outside the record, but some of us here have handled a bunch of cases that involved mandatory life sentences and that were warranted, and there were never plea negotiations in those cases, because those are the worst of the worst. They get the sentence that they're entitled to. I guess I'm not sure, I don't see what's extraordinary. It's extraordinary that your client was involved in this offense. I agree with that. But once we're there, that doesn't seem that extraordinary to me at all.
I'd like to make 2 points on that. The first is that was addressed by the petitioner through an affidavit from William Purpura, a very experienced criminal defense attorney who essentially said, yes, that it is fundamental to the role of defense counsel that they must try to plea out a case like this, and that a plea could be had.
Oh, I'm sure that the defense counsel wants it to plea, but what you're saying is it's extraordinary, like that there's no plea offered, that there are no plea negotiations. That's not extraordinary.
Well, from the record, and the thing that we have on
No, but what he says is that that's what you should do. That's not whether it happens, right? He's not making an empirical claim. I don't understand his affidavit to be an empirical one.
Well, there's also statistical support, which is cited in the brief. Something like 95% of all federal cases are pled out.
And what proportion of those are involved situations that are involved death-eligible offenses?
And well, let me address that for a little bit, because there is a very big distinction here between Mr. Leidy, the co-defendant against whom the government sought the death penalty, and Mr. Flood. Mr. Flood was not the shooter, right? He didn't drive the vehicle. He wasn't even physically present when the murder occurred. And perhaps most significantly, this was not his beef. He's not the one who...
Does that make it better or worse, that it's not his beef?
In terms of culpability, it makes him far less culpable. He's not the one who instigated this. He's not the one who pulled the trigger. And those are the co-defendants. And again, we're all experienced with these cases, and Your Honor certainly is, and I certainly am.
but you're not holding any cards. You're not holding the cards. You've got an individual who lied in grand jury testimony and lied during the investigation. and is going to be impeached if he ever goes into, if he was a witness for the state during the trial, he was going to be blown out of the water. So you say, well, you know, what do you have to offer the prosecution? The only thing you have to offer the prosecution is to get out of a trial. But why would the prosecution want to get out of a trial in a case that involved the kind of heinous offenses that this one did? I just don't see what you have. Normally, to bargain, you have to have something that each side can offer the other. And you've got, unfortunately, a person whose reputation for truth is, to put it gently, blemished. And you can't bargain, and the only thing that you have to offer the prosecution in this way is, we can get you out of the effort of having a full trial. We can spare you the effort. But that's all you have to offer, and there's no indication that the prosecution would take that as a reason to bargain, given the seriousness of the offense that was involved here, and given what ultimately the jury found. Is probably what makes sense that they should have found, that there was, that this individual, after an 11-day trial, was guilty of kidnapping resulting in death.
Your Honor, it's
You're not holding cards.
Well, that's a great question, right? Your question is, what cards are they holding? And that is precisely the type of question that we would like to ask the prosecutor, defense counsel at an evidentiary hearing. If there's no cards being held, why did the prosecutor during jury selection reach out to defense counsel and say, hey, what's going on here?
So you agree, I want to make sure I'm very clear. You agree that you could not win this IAC claim without showing that the government actually would have made a plea offer. You agree with that, right? Well, or, sorry, a reasonable probability.
Reasonable
Sorry,
probability,
I was
yeah.
shorthanding, I'm sorry. But that's to win the IAC claim. But your argument is that we need an evidentiary hearing. And so maybe you'll lose at an evidentiary hearing, right? Maybe the
Sure.
judge decides that everything is not true. But just so I understand, the argument is only about an evidentiary hearing?
That's absolutely it. And I think you're absolutely right about the reasonable probability. That standard, as defined by Strickland, is less than a preponderance of the evidence. That's all we need. And that's all we need to win this case, much less to get to the evidentiary hearing. Thank you.
Thank you. Ms. Munoz, pleased to hear from you.
May it please the court, MJ Kirsch Munoz for the United States. In his opening brief, Mr. Flood purports to identify one and only one dispute of fact that, in his view, deserves an evidentiary hearing. And that is whether the government would have offered a plea deal to Mr. Flood. But in fact, there is no dispute on that question, because everyone agrees, Mr. Lawler agrees, Ms. Wilkinson agrees at AUSA below, that the government would not have done so without, at a minimum, first obtaining a proffer from Mr. Flood.
Ms. Munoz, can I take you back to what is honestly my single biggest concern in this entire case, other than,
Please.
the facts of the case?
Please
So
do.
this is JA 249, page 21. The district court wrote a sentence that I literally stopped reading and, had to clear my head. It is settled that evidentiary hearings on 2255 petitions are the exception and not the norm, and there is a heavy burden on the petitioner to emphasize that an evidentiary hearing is warranted. And then we cite an out-of-district court opinion for that rather striking proposition, because that is literally the opposite of what the statute says. Do you disagree with that?
I do not disagree with that. I missed
So
your...
where did that crazy idea come from?
I am not quite sure, Your Honor. I do not disagree that is
Not the legal standard? That's
Right.
not what the statute says? That is
Right.
not what Mayhew says? That is not what, and with all due respect to the Eastern District of Virginia, that is not the law in the Fourth Circuit?
Yes, that is, I would agree with you on all of that.
Okay, so let's talk about what the standard for granting an evidentiary hearing is. According to the statute, what it says is if the files and records in the case conclusively show the petition, unless the motion and files and records in this case conclusively show the prisoner is entitled to no relief, the court shall have a hearing. That's the legal standard, right?
That is correct.
And to the extent that there was any doubt about what those words meant, you know our decision in Mayhew, right?
Yes.
And you know what our decision in Mayhew says about when you have to have a hearing.
Yes.
And what our decision in Mayhew says is, quote, this is page set 176 to 177, a hearing is required when a movement, a colorable Sixth Amendment claim showing disputed facts beyond the record, whose credibility determination, that's the legal standard for granting a hearing, right?
Yes.
How did the district court not egregiously fail to file that legal standard? That is not the standard that I read. When I read this opinion, I am not seeing a district court applying that legal standard.
I agree that the district court stated the wrong legal standard, but I think regardless, this court should affirm the denial of 2255 relief because there is no dispute of fact, of relevant fact, on the question of whether Mr. Flood would have received a plea offer from the government. The evidentiary hearings are, of course, meant to resolve
Can I go back to Judge Hyden's case? Because I found this to be interesting, too. What is the standard? And he goes to Mayhew. As often the case, I sort of find great guidance from Judge Motz in her earlier decision in White, where she sort of seems to lay out like a slight, this is obviously an earlier case, but that's not sort of the interesting part about it. It like actually points us to the Supreme Court case that addresses this. But she seems to suggest that there are two things that happen. There's a motion to dismiss. That's the summary dismissal before response. And then there's just like ordinary summary judgment, which is like before a hearing. The court does that relying on the Supreme Court's decision in Blackledge, which sort of seems to tell us that. Is that the way that you think about it? That like at step one, there's a motion to dismiss standard that sort of applies, like they haven't alleged anything that even warrants a response. And then at the next step, what Blackledge talks about to determine whether a hearing is necessary, the Supreme Court sort of explains and Judge Motz sort of re-articulates in 2004 that we're applying effectively a summary judgment standard to determine whether a hearing is warranted.
Yes, I think that is how I would approach it as well, Your Honor. I think evidentiary hearings are meant to allow the petitioner to prove the facts that he has alleged in his petition. But here, the government's position is that he hasn't alleged facts.
Okay,
that
so
would have been
JA 92, paragraph 2, all I wanted to do was avoid getting a life sentence. Why doesn't that suggest he at least plausibly alleged that maybe he would have been willing to do anything, including proffer, to avoid a life sentence?
I think there's nothing in the record to suggest that the government, even if Mr. Flood said he would have proffered, put in evidence that he would have proffered truthfully, would have cooperated, would have done whatever is necessary to get a plea, there is, in fact, nothing to suggest that the government would have offered a plea.
Except the sense that they literally approached him during jury selection and say, hey, do you want to talk about a plea? And just like we can take judicial notice of what reasonable prosecutors can do, I think that goes the other way. Surely prosecutors don't think he's going to plead guilty to a mandatory life sentence, right? Like when you say, hey, maybe we should talk about a plea, and then the defendant, the first question the defendant's going to ask, like, what might I get out of this? And in this hypothetical where the prosecutor says, you get the same mandatory life sentence you get if you go to trial and lose, the defense would say, maybe we don't understand how negotiations work. I get the thing that you want even if you win is not the constructive start to a negotiation.
That's actually how most plea negotiations go, right? That's actually how, often plea negotiations do go. You plead guilty to the life sentence, and you may work down from it based on cooperation. That's how most mandatory life sentence plea negotiations look, right?
I might agree with that, Your Honor. I think that, the government made no promises or assurances that if Mr. Flood would have proffered, if he then would have cooperated, that would have inevitably led to a plea agreement here.
Not inevitably. Whether whether the facts in the record right now conclusively show there's not a reasonable probability. That's the legal question, isn't it?
That is a legal question, Your Honor, and I would also, observe that even if he can show a reasonable probability on the, the facts in the record, or even facts at an
But
evidentiary hearing.
what evidence is there that the outcome would have been any different? Much less a reasonable probability that the outcome would have been different if counsel had pursued a plea bargain. And the problem is that there are two reasons to think that there's no reasonable probability that the outcome would have been different. And so you falter on the grounds of no prejudice. And one of the reasons is the seriousness of the offense. But the other reason is would be a very poor witness, because there were two different instances where he had lied. Number one, in the grand jury testimony, and number two, during the investigation. And so the prosecution here had someone who was simply not a very worthwhile witness. And they have also a very serious offense. And so how is the outcome going to be different in any meaningful sense if counsel had pursued a plea bargain? He was simply running up against obstacles, both in the serious nature of the offense and also because he was a lousy witness and he didn't have much to offer. And so has the reasonable probability standard met, given the problems that they don't have much to offer in terms of cooperation or whatever you can? That's the problem.
Yes, Your Honor, I would agree with all of that. I do not believe that the facts alleged in the petition, have satisfied the reasonable probability standard that is applied in Lafleur-Frye cases of ineffective related, or
It's
rather
not just a
plea-related.
possibility that it's going to be, that there's going to be some sort of difference. There has to be a reasonable probability. And did the district court abuse its discretion in finding that there was no reasonable probability here, given the difficulties that I just alluded to?
No, our position is that the district court did not abuse its discretion because.
Can I now ask you that? Because Mayhew tells me how I apply the abuse of discretion standard. I agree it's abuse of discretion. Mayhew says it's abuse of discretion. But then Mayhew announces a substantive legal standard for when you have to have a hearing. And we agree that district courts don't have discretion to violate the substantive legal standard, right?
Correct.
So it's not like the judge just gets to look at all the facts and decide, you know what, I think this guy's almost certainly going to lose, and it seems like a hearing is kind of a waste of time. So as part of my discretion in case management, so for example, I know that in the District of Maryland, for instance, we never have hearings in civil cases. They always no hearing is necessary, see local rule blank. That's not the standard for granting a hearing in a 2250. A district court judge doesn't get to just not have a hearing in a 2255 because they don't think it's going to be a good use of time because the prisoner's ultimately almost certainly going to lose, right?
Correct.
Okay, so we don't defer to the district judge on whether he thinks it's a good idea or a good use of time to have a hearing in a 2255 case.
I agree with that, Your
Okay.
Honor. Yes,
Can I ask just a follow-up question to that? This is just like a confusion on my part. I don't know. So there was a hearing in this case, right, on the 2255?
Yes, there was.
Right, they held a hearing. What they didn't do is hold an evidentiary hearing. Where do we get the requirement of an evidentiary hearing? I get the requirement of a hearing. 2255B says that you're entitled to a prompt hearing thereon, right? But why? I understand why it makes sense to have an evidentiary hearing, but is that actually the requirement as opposed to having a hearing itself? It seems like in some sense, if we're really just looking at 2255B as an example, they had a hearing. Is there a reason that I should think it's required to be an evidentiary hearing?
I think, that the standard is unless.
How about page 176 of Mayhew, where it says the words, "An evidentiary hearing is required unless that standard is satisfied"? Mayhew literally says it, doesn't it?
Yes, that's right, Your Honor. And I do think that there is, in all candor, a difference between the hearing that was held in this case and an evidentiary hearing. Unless the record conclusively shows it's a standard, a hearing must be held. However, the district court, I think, rightly concluded that the facts alleged in the petition were, were not of the kind that if
The
an
district court
evidentiary
rightly
hearing-
concluded applying a legal standard that seems to be 180 degrees from the actual legal standard?
Regardless of the, I think the district court reached the right result, and I think this court can still affirm on any basis in the record, and so we would ask the court to
Just as a
affirm.
matter of practice, aren't there? I mean, I feel like I've seen a lot of these cases where there was a 2255 motion based on ineffective assistance of counsel, and they've been resolved as a matter of practice without an evidentiary hearing where the district court did not feel that the evidence or that the arguments warranted, the evidence warranted an evidentiary hearing. In other words, I'm wondering whether that, and I appreciate the language that my colleague Judge Heitens has brought forward, but as a matter of practice, I've been in many situations where a district court would say an evidentiary hearing would be just useless because the evidence for ineffective assistance of counsel is so weak that it just doesn't even begin to hold up. I mean, let's take the classic example of where you have an ineffective assistance of counsel claim that's brought forward, and the thing that is alleged in terms of ineffective assistance of counsel is an omission on the part of counsel, and yet the evidence is tendered that there was no omission at all. Counsel did the very thing that counsel was not accused of not doing. Now, would you have to hold an evidentiary hearing in a situation where the record conclusively proves without an evidentiary hearing that the very thing counsel was accused of not doing, the lawyer actually did? So the point I'm making is I don't think as a matter of practice that every single claim under 2255 requires an evidentiary hearing categorically, no matter how weak and feeble the claim is. I mean, this would be quite a shift in practice. I think when it's in doubt, obviously you should, if there's an arguable point to be made, yes, you should have an evidentiary hearing. But many of these cases are just absolutely frivolous, and I'm thinking as a matter of practice, this would come as quite revelatory to district court judges to say that they've got to have an evidentiary hearing in every ineffective assistance of counsel 2255 motion that comes along, because some of these are just frivolous from the outset. And so it can't be that this is an invariable requirement. If it is, we have effected essentially a sea change in practice.
Yes, I agree with all of that, Judge Wilkinson, and I will also say that, the Mayhew case that Judge Heitens and I have been discussing, the underlying thread there is that a movement must present a colorable Sixth Amendment claim.
Yeah,
And so
basically the summary judgment standard, right?
Right. So if the claim is not colorable, then of course an evidentiary hearing is not required. And it's the government's position here that this claim is not colorable, that even if Mr. Flood got the opportunity to say everything that he wanted to say at an evidentiary hearing, which, by the way, he did not allege the facts in his petition that he is now suggesting an evidentiary hearing was required on. But even if he were permitted to come into court and talk about whether he would have proffered, whether he would have cooperated, whether he would have done X, Y, and Z, he is still miles away from showing a reasonable probability of prejudice under the relevant Lafler-Frye standard for plea-related ineffectiveness claims. I mean, he is even still miles away from showing a reasonable probability that the prosecution would have offered him a plea deal, which, by the way, is the premise that both Lafler and Frye took for granted, that there is a plea offer already on the table that for some reason was not accepted by the petitioner in those cases. So, I think it's notable, or I think I will, if helpful, recite that standard here. He must show a substantial, not just conceivable likelihood that the prosecution would have offered a plea deal. That's number one. That he would have accepted the offer's terms. Of course, we don't know what those terms are in this case because no plea deal was on the table. And there are questions of remedy there. Can you ask the prosecutor to renew a plea offer that was never made in the first place?
So you make a big stink about that in your brief, and that admittedly strikes me as a tricky question, and my tentative thought would be no, you can't, because all the points you make, like you can't force the executive branch to offer someone a plea agreement. I mean, and so when in cases where there was a plea agreement on the table, we say, well, that's just enforcing the contract they already made. You can't make them make a contract. But then I realize this is like 10 steps down the road. But why wouldn't the remedy in that situation? So if the violation was, I know, let's assume a gazillion assumptions you're not going to agree with, but if there was a constitutional violation, why isn't the remedy the fairly common remedy in post-conviction litigation and say, well, the remedy is we vacate the wrongful conviction to restore the parties to the position they would have been but for the violation? And if the government wants to say, cool, no plea, we're going to trial again, we go to trial again. And if the government wants to say, actually, I just don't think that remedy point is quite the silver bullet your brief presents it as, because it strikes me that there would be a remedy. It's the remedy that we normally do in 2255, put people in the position they should have been in, and then they can go forward through the process again, and the process turns out however the process turns out. Why wouldn't that obviously be the remedy?
I think that could be the remedy, Your Honor, and I don't want to harp on it too much. I did put that in a footnote, and I didn't intend for it to be any kind of silver bullet.
No, it wasn't just in a footnote, though. There was the whole discussion of, like, how could it possibly be IAC if the government didn't actually offer you a plea deal? And it strikes me that the answer is pretty obvious. It could be because, right, it's not just the footnote, but I take your point.
But, I guess my larger point is that if the Strickland claim isn't colorable in the first instance, then no evidentiary hearing is required, and that does require us to take a peek at the merits of his claim, which is the failure to unilaterally resolve this case by plea resolution. And so, we have a need for him to prove, Mr. Flood to prove that the prosecution would have offered the plea deal, that he would have accepted the terms, that the prosecution would not have withdrawn or canceled, that the court would have accepted it, and that he would have received a more favorable sentence. And we are taking speculative leaps on each of these showings that must be made. And I see that my time is about to expire. I am happy to continue to address, the court's questions, but I will just reemphasize and point the court maybe to Merzbacher versus Sheeran, in which this court found no ineffectiveness, no prejudice, because the plea offer was in such an incipient stage, such a nascent plea offer, that it would be too speculative to find prejudice there. And of course, we don't even have a nascent plea offer here. We have no plea offer. And I see my time is up, and I am happy to answer any additional questions or.
Jay, you okay?
I'm great.
All right, thank you
Thank
very
you.
much.
We ask the
And
court
let's
for-
hear from Mr. Brown in rebuttal.
Thank you, Your Honor. I'd like to point out a few facts that I think are relevant to the discussion that was just had. First of all, in the government's brief, presumably authored by Ms. Wilkinson, there was a roadmap laid out of what a plea would have looked like. And that's it's a JA 109. And it's not perfect, I'll give you that, but there are some things there. She says it could have been a possible recommendation from the government of 2 levels for substantial assistance. And she also says something interesting there that appears to be that he could have pled to murder, which of course is different from kidnapping resulting in death. And certainly that would be an interesting thing to explore at an evidentiary hearing, exactly what she meant by that. She also said that the government would insist on a 2-point enhancement for obstruction of justice. So again, while that's not perfect, it does lay out a little bit of a roadmap which could be fleshed out at an evidentiary hearing to try to determine what, if any, plea the government would have offered.
So when is an evidentiary hearing required in your view, and when is it not? Or do you think there's a 100% requirement that a district judge hold an evidentiary hearing? Or do you think an evidentiary hearing is only necessary if there's a genuine dispute? Or what is your view as to when an evidentiary hearing would be required? Is it an inflexible requirement?
I think it's again, it's flexible. The petitioner needs to make a colorable claim, which.
Yeah, okay, so maybe we might be on the same wavelength here. And that is, was it an abuse of discretion for the district court to say that there was no colorable claim here in light of the two factors that we all know are there, and one being the seriousness of the offense, and the other being the fact that he is a proven prevaricator, and that would seem to argue for the fact that there was no abuse of discretion in reaching the conclusion that the plea negotiations would have been fruitless.
Your Honor.
And you've got the affidavit to back that up.
The problem with this case is that the record as it currently exists is extraordinarily messy. There are contradictions to the left and contradictions to the right. What the district court did was took the prosecutor's word, which contradicted itself, and took that as the gospel truth and disregarded everything that came from the other side. I mean, that's the core of the problem. Mr. Lawler's statement, right, his affidavit, which unambiguously stated that the government tried to initiate plea discussions, that was completely discounted without any hearing.
Can I ask a question about that? I think you said in the opening, I just want to make sure I understand the argument. You made a reference that that discussion, whatever it was, about proffer or cooperation, you suggested that that was not told to the defendant, to Mr. Flood? Is that?
That's what the record indicates.
Where would I find that in the record? And then second, that's not a claim, like you haven't brought that claim. I mean, I don't think it would work under Lafler, but that's not, you haven't brought sort of a failure to communicate that, whatever it was, I'm not, discussion.
That would be a Fry claim, and we're not bringing a Fry claim here.
Yeah.
Ours is more general, that it was just ineffective assistance of counsel in the plea bargaining phase. And the fact that that was not communicated to Flood comes from the Lawler affidavit. Lawler says in his affidavit that he did not communicate that to Flood.
Okay, thank you.
So, and to get back to Judge Wilkinson's question, I absolutely am not suggesting that there needs to be an evidentiary hearing in every case. But in this case, where there are material facts that are hotly contested, where the record is unclear, this is an exception. This is an extraordinarily unusual case. I assume that's why the COA was granted here. But in this type of case, yes, an evidentiary hearing is needed.
I have no doubt that they're contested and they may be in dispute. The question is, were they so genuinely in dispute that it would give rise to a reasonable probability of difference had there been plea negotiations? And, you know, I just am hard pressed to see what kind of cooperation or whatever the defense would have been able to offer that would have resulted in some sort of a more favorable deal, but that's, I think.
And again, there must have been something, because otherwise the government would not have reached out to defense counsel. And I would point out the fact that here we are, right now, arguing over the facts, over whether there was a
The fact
plea.
that the government reached out, that's only the first step. I mean, there's a long road from saying, well, what about the possibility of a plea, and then actually getting down, you know, the devil is always in the details on these kind of things, and when the rubber hits the road on this situation, then it's pretty easy to imagine prosecutorial resistance.
And you're right, Your Honor, things can go wrong along that path. But what we're looking for here is, was there a reasonable probability that a plea offer would have been extended? And then, is there a reasonable probability that it would have been accepted?
And the assessment of reasonable probability, as I understand it, is subject to the abuse of discretion standard.
I'm not sure I would agree with that. And again, that's not before the court here, but further down the road, I think that would be a mixed question of fact and law, and I think that standard would be a little bit different. But where we are here are we've got this muddle of facts that need to be resolved. It's an unusual case. The facts here are unique. This isn't Lafler, this isn't Fry, this isn't Pender. It's its own unique case, and the solution for that is an evidentiary
You
hearing.
know, it's an interesting thing, because I always have able counsel, and you certainly are able, always say, this is an unusual case, this just has unusual characteristics. And then a month later, or 2 months later, I am facing arguments that this case laid down a broad and significant rule, which I am obliged to follow. And so every soothing assurance that is given to me about something being idiosyncratic and unusual, I find 2 or 3 months later that, hey, it wasn't unusual at all. So, you know, I have to be a little bit careful about being taken in by that. You see?
I understand where you're coming from, Your Honor, very much.
Well, you see, you're court appointed, you've done a fine job. I really appreciate your argument and express the appreciation of the court for your taking this case on. And Judge Richardson, do you have anything further? Judge Hayden?
I do not.
We have nothing further.
Thank you, Your Honor.
We thank you. We'll come down and say hi to you and then go right into our last case.
Great.
right, Mr. Prescott, please be seated. I'm happy to hear from you.
May it please the court, my name is Ryan Prescott. I represent the appellant, Robert Strother. Unless the panel objects, I'd like to start by discussing the constitutional and statutory framework for appellate review of departure sentences since this court's decision in Rybicki. The government's response brief argues that Booker invalidated Rybicki by severing and excising section 3553b1 in its entirety.
I guess another question I have is why doesn't, to the extent that anything remains of Rybicki after Booker, why doesn't Kimbrough just utterly finish it off? Because Kimbrough could say, like, so this whole framework is I can only depart upward if I'm taking into account something that isn't adequately taken into account by the guidelines. And Kimbrough says, I can just say, I don't care what the commission thinks. I'm doing X. Right? Like, I just don't understand how, again, if Rybicki has any legs after Booker, Kimbrough doesn't just destroy the rest of them.
It's not clear to us, Your Honor, that Booker impacted this court's analysis in Rybicki much.
Impacts? It seems like it obviously impacts.
Well,
But again,
but
I really get the whole framework of Rybicki, and this makes sense. This makes total sense in a world of mandatory guidelines. In a world where the district court has to follow the guidelines, it makes sense to say you've got to really police variances or let me preface this. I do not understand the difference between a variance and a departure. And I, frankly, in a post-Booker, post-Kimbrough, post-Gall world, I don't know why I care about the difference between those things. Because the whole premise in Rybicki was, and this, again, it makes total, in a pre-Booker world, district judges have to follow the guidelines. Well, sometimes they might really not want to follow the guidelines. And they might try to get around that by using this little trick called a departure or a variance or whatever the heck it's called, which means we have to police their ability to do that because otherwise they can just completely get out of mandatory guidelines, which is all well and good, except then Booker makes the guidelines non-mandatory, and Kimbrough, I'm going to paraphrase, but Kimbrough essentially says they can just say, I don't care what the Sentencing Commission thinks. And so now I just don't understand why any of this framework makes any sense anymore.
Well, the Sentencing Commission agrees with you, Your Honor, and departure sentences are going away a week from Saturday. But for the time being, this court and the district court apply the version of the guideline, the guidelines applicable to Mr. Strother's offense conduct, and so we're proceeding.
But the district court sentenced in a world that Booker and Kimbrough had been decided.
Yes, Your Honor.
Okay.
Our view, and this is consistent, I mean, with the way the commission describes the post-Booker, post-Rybicki framework for departure sentences, is that following Booker, district courts effectively have two separate procedural tracks by which they're permitted to impose sentences outside the advisory sentencing guidelines. They're permitted to impose, as you say, pursuant to Kimbrough, pursuant to Gall, pursuant to Booker, a variant sentence.
I do what I want, right. I mean, I do what I want consistent with 3533. No one is saying they get to do what they want writ large, but I will simply apply 3553.
Yes, Your Honor. Alternatively, they can choose to proceed instead of proceeding pursuant to the sentencing authority set forth at 3553A and set forth in Booker, they can proceed pursuant to the sentencing authority set forth by the departure clause of section 3553B1, which says the district court may impose an outside guidelines sentence based on specific circumstances of a kind or of a degree not adequately taken into consideration by the guidelines. That's the statutory.
But how did the variant sentence, I mean, because I think that the departure grounds are subject to probably greater degree of restrictions than variant sentences are. And how does the variant sentence, did that depart from the 3553A factors? I realized that it was a very significant variation from the sentencing guidelines. Maybe not with respect to count 2, but with respect to count 3, the movement up from what the guidelines recommendation, I guess, was 120 months, and the sentence imposed by the court was 300 months. So that was a significant variance, but how did the variance, the district court explained it, how did the variance vary from the 3553A factors and specifically the danger of recidivism? I mean, the part of 3553A is punishment, and punishment certainly seems to fit here, given the absolutely horrendous, monstrous nature of the conduct. So there was just punishment, and there was also no assurance that the district court had that this kind of murderous behavior would not be repeated. And that's the danger of recidivism and repetition is also a 3553A factor. So yes, it was a steep, particularly on count 3, the jump from 120 months to 300 months was a significant variance. But the question is was it related in some way, or was it unrelated to the 3553 factors to such an extent that we can strike it down as an abuse of discretion when the whole purpose of Gall seems to be to put district courts in the primary position, in the primary seat with regard to sentencing. It makes it much more of a discretionary exercise. And how does this depart from the 3553A factors, given it's hard even to read about what happened to this man and the fact that he was, just shot point blank and spent the rest of his life in a wheelchair and came within an ace of being killed, and also that was right on the heels of the shooting at Deputy Key. And the district court explained, I don't have any confidence that this isn't going to be repeated. And I don't see how that is an abuse of discretion, because these are very serious offenses.
So just to make sure I understand Your Honor's question correctly, the question is regarding whether the alternative variant sentence announced by the district court kind of obviates the departure sentence question? Is that do I understand you correctly?
No, I'm the one that asked the questions.
Let me phrase it this way. How in the world is this sentence substantively unreasonable?
Yes, Your Honor. In order to discuss the alternative variant sentence and the substantive reasonableness of the sentence, I'd like to take a step back. Sentencing, federal sentencing, since Gall, since Booker, is governed by this tension between, on the one hand, the Sixth Amendment says we can't, the discretion of the sentencing judge, that's the red line we can't cross. But Booker, although it does make clear that that's the line you can't cross, it also makes clear that the guidelines it doesn't make the guidelines fully optional. It makes them advisory. They're not mandatory. You can go outside them if you want, but you do genuinely have to think about them because Congress enacted the statutes that serve as the legal authority for the sentencing scheme.
You didn't genuinely think about them as a procedural reasonableness challenge. I'm asking why, but you're not making a procedural reasonableness challenge. You're making a substantive reasonableness challenge.
So just to set that tension up, I believe, and I think the next step in the argument for us, Your Honor, is the answer to your initial question, which is our position is that since Booker, the departure clause of Section 3553B1 has continued as an alternative viable track for the district court to go outside the guidelines. It can either impose a departure sentence, which is based on sentence within the guidelines.
But this district judge accepted the invitation that we gave district courts and says, by the way, so you have to calculate the guideline sentence. You have to figure out what the right answer is under the guidelines, and you have to explain if you're going to depart, why you're going to depart. But also, again, under Booker, under Gall, under Kimbrough, you also can just say, I'm not going to follow the guidelines and I'm going to apply 3553. And if a district court says that in the alternative, as this district court judge did here, and you don't challenge that what he said here was sufficient to say that, then we just skip directly to the question of, is this a reasonable sentence under 3553? And so then I'll re-ask my question.
Yes, Your Honor.
Why is this a substantively unreasonable sentence under 3553?
Two pieces to that, Your Honor. I think first, this court can't consider the substantive reasonableness of the sentence in a vacuum. This court held back in Myers and Williams, kind of in the same line of cases as Rybicki and Kuhn, that when a district court bases a departure on both permissible and impermissible grounds, this court's harmlessness analysis requires it to determine that the impermissible ground did not affect the court's ultimate imposition.
The impermissible ground is getting the guidelines wrong? If that were true, then we could never do this assumed harmless error. It can't be that the harmful ground is you got the guideline. We can't say, because you got the guidelines wrong, saying you would have done the same thing not under the guidelines can't be harmless error because you got the guidelines wrong, because then you could never do assumed harmless error.
I think in a case like this, where it's a question of which of these two procedural avenues, the departure clause in 3553B1 or the variant sentence under 3553A, I think Your Honor is correct. I think I have to agree that if the district court had given the exact same 3553A analysis at the end of the sentencing hearing in support of a within guidelines sentence or within a variant sentence with no discussion of these departure provisions, that likely would have been sufficient to establish the substantive reasonableness of the sentence.
Given the district court's reasonableness, the district court is not going to come off this sentence if there's just a remand to reconsider or do this or do that. He's given detailed reasons for why he imposed a sentence, and he's not going to come off the sentence unless we absolutely forbid it. So in order to do anything with it, we have to find it, as Judge Hyten said, to be somehow substantively unreasonable. And in light of the gruesome behavior, and in light of the district court's explanation, quite accurately, of the heinous injury that was inflicted upon these poor victims, what in the world, what grounds do we have for saying, oh, what you did was unreasonable?
Respectfully, Your Honor, we don't agree that the district court set forth detailed reasons in support of its sentence. The district court engaged in an extended discussion of the severity of the offense conduct, and it listed several of the identified factors as potential bases for departure in Chapter 5 of the guidelines. But the critical omission here, as required by Rybicki, as required by this court's general standards of review for even under Booker, even under Gall, the district court made no effort to compare the severity of the offense conduct in this case to the severity of the offense conduct contemplated by the heartland of the advisory guidelines that already served as the basis for Mr. Strother's guidelines range. And so that linkage is missing.
There are not that many other cases out there which have afford a basis for comparison, given the two different shootings, each of which had its own gruesome facts surrounding it. I mean, how many comparable offenses are there out there? Not that many.
I have four cases involving severe physical injuries to law enforcement officers out of the Eastern District over the last couple of years, Your Honor. In August, the Eastern District sentenced Daniel Locklear to 180 months.
Yeah, but this is right up there with capital punishment. I mean, with capital sentences. I mean, in a sense, the defendant is lucky to have not had a capital charge because the injuries inflicted stopped just short of taking the person's life. But I just don't know how many comparable situations there are.
As a descriptive matter, Your Honor, these cases tend to fall far below de facto life sentences. In August, Daniel Locklear fired 16 times into a gas station and severely injured an off-duty law enforcement officer.
That's only one of the 3553A factors to which you've alluded. There are others, including deterrence of future behavior and punishment and heading off recidivism and the rest. So comparison shopping is only one of many
I apologize, Your Honor.
Where in the briefing would I find the comparison to lock? I want to be able to look at them, but where is this in the briefing?
I prepared those for discussion at argument today, Your Honor. It's that there's-
This is not an argument that you made in the briefs?
we didn't have these case references in the briefs, Your Honor.
okay.
I apologize.
All right.
As far as substantive, as far as the alternative variance, I would also just point this court to this court's recent decision in Florentine, where this court kind of explicitly suggested that a district court can't insulate a sentence from vacatur through a general statement that it would have imposed the same sentence regardless of any error. This case closely resembles that in our view, Your Honor, and I'm happy to discuss that further, but I see my opening time has expired. Unless the panel has
All right.
questions.
Thank you, sir.
Thank you.
Ms. Noakes, pleased to hear from you.
Good morning, Your Honors. May it please the court, Sarah Noakes, on behalf of the United States, asking you to affirm the judgment of the district court. Here, the district court reasonably imposed a 720-month sentence for the defendant's crimes, which it called horrifying and extraordinary. This case is about the defendant's 48-hour rampage, during which he shot a police officer in the neck with a high-powered rifle. And then during the ensuing manhunt, he ambushed a grandfather, carjacked him, and then shot him 3 times, causing, as Judge Wilkinson has pointed out, heinous injuries to that person. Then the next day, when police finally caught up with him, he raised that same rifle as if to fire on them. It was set to fire, the safety was set to fire, he pointed it at police, but thankfully he was apprehended without further injury. Now, the court in this case reached this sentence after accurately calculating the guidelines, and it seems that my colleague has questioned whether the guidelines were accurately calculated, but the parties...
only variance here really was with respect to count 3, wasn't it?
That is correct, Your Honor, because for counts 1 and 2...
Because count 2, there was a sentence imposed by the court of 420 months, but the guidelines recommendation was 360 to 420. So there wasn't any variance with respect to count 2 of this indictment. And the variance here was with respect purely to 1 count. So he followed the guidelines recommendation elsewhere, and the variant sentence was from 120 to 300 months. And that's what we need to focus on, just that variation, not other aspects of it. I don't think there's any objection raised to the fact that these were consecutively imposed or what have you. It's just that variation. And your straightforward argument is that in light of the heinous nature of these particular offenses, that the variant sentence was amply explained and amply justified.
That is correct, Your Honor, but it wasn't just the circumstances of the offense. The district court conducted a thorough and individualized assessment of the defendant as a person and of his crimes, and then considered all of the 3553A factors, the goals for federal sentencing, and applied the logic in that to this defendant and his crimes to come up with his sentence. So as to the nature and circumstances of the offense, which again it called extraordinary, including the defendant's attempts to kill 2 people, infliction of horrifying injuries resulting in amputated fingers, surgeries, loss of internal organs, and the ripple effect of psychological trauma on these victims' families and on the community. The district court noted that other than murder, it really couldn't get more serious than this. These circumstances are about as serious as it gets. Then the district court turned to this particular defendant, and the district court considered defense counsel's mitigation arguments as sentencing, but it also considered the fact that this man had a 17-year criminal history, which included violence, unlawful weapons possession, resisting arrest, property crimes, and drug offenses. He'd had repeated failures while under probation supervision, including by the commission of these actual offenses, because he was on a post-release term of supervision for the last time he seriously injured a cop. At the time,
The rap sheet of the North Carolina rap sheet has to be seen to be believed.
yes, sir, Your Honor, we would agree.
So can I ask you, unclear to me if this affects this particular case, but I have a couple questions about, so I think from your brief that you kind of agree that to the extent the district court relied on 5K 2.21, that was actually just wrong under the guidelines.
Yes, Your Honor, we have conceded.
And so, but then what you move on to say is, well, no, this couldn't support, I'm going to get the numbers wrong, but as I recall, the district court gives two reasons. Identifies two provisions of the guidelines. You say one of them is valid, you concede one of them is valid, but suggest that in fact, one that the district court didn't cite could have also supported the departure.
Yes, sir.
Are we allowed to do that? That seems a little strange, that like, we're allowed to say, the court was wrong to rely on the provision it actually cited, but the things it cited could have supported under an abuse of discretion review reliance on a different one, so we're going to assume that it relied on the one it could have relied on as opposed to the one it actually cited?
Your Honor, the importance is that the factors that the district court was considering, so in that 5K 2.21 analysis, it was considering the fact that the bullet from that high-powered rifle.
No, I'm not asking you about the facts of it. I'm asking you a conceptual question about when a district court gives a reason, the district court gives a reason and identifies a provision of the guidelines that it believes apply to that reason. And in a reviewing court, in part because of the candor of the government, when it concedes, actually that doesn't work, you can't do that. I'm just not sure that as a matter of appellate review, we can then say, but then we can jump to another provision the district court didn't rely on in defending the sentence the district court imposed. I'm just not sure conceptually that works.
Well, the other provision here is sort of a catch-all provision for departure.
But that's not the provision the district court relied on.
And that's fine. The district court sentence is saved in all ways.
No,
by
again,
departing
I
variance.
preface this by saying I'm not sure it affects the outcome of this case. I just am not sure, like, I'm just not, we give district courts lots of discretion, but I'm not sure as part of giving discretion, we can say, let's assume they relied on a provision that they didn't cite and say, we'll save the sentence that way. I'm just not sure, and I didn't see any authority in your brief for the proposition that we're allowed to do that.
Your Honor, and we didn't
We
find.
do that in like evidentiary context, right? We have said that if the district court cites a hearsay provision that doesn't apply, as long as a different provision would apply, that it's not an abuse of discretion. Is there a reason to think, I have no insight into this, it's not a loaded question. Sometimes I ask loaded questions, you may notice that. But this is like totally curious. Is there a reason to think that like that evidentiary line is different from the sentencing line? They're both places where we would give like a lot of discretion to our district court colleagues?
I don't think that there's a clear line here.
Really? Because I think one of the justifications for the evidentiary context is trials are hard and making decisions on the fly in the moment. People say a lot of things, they pop out of their mouth. We're not going to fly spec what a district court says in overruling an objection in the middle of the trial. But like, this is what the court literally said in sentencing a criminal defendant.
That is correct, Your Honor, but the standard of review is the same for both, the same abuse of discretion. So we don't think that it makes a difference here, but don't take our word for it. You can look at prior cases where courts have determined that one departure provision used by a district court in imposing a sentence didn't work, was a bad departure provision. And yet they still said, well, if the court would have imposed the same sentence and the grounds that the court considered weren't not allowed, then it's perfectly fine for the court.
And I know we've said that. Let me ask you about I was asking your friend on the other side a question about the relationship and why I think one type of thing doesn't work. But I'm also thinking that it can't possibly be fully right. So let me give you this hypo and ask you how you would work through it. Say a judge relies on an obviously improper ground to depart significantly upward, like obviously, flagrantly, no even arguable basis of doing it. Maybe even one that violates the Constitution, right? Like the court relies on it for a departure, something that is flagrantly illegal. And maybe even unconstitutional, and then after that says, and if I was wrong to do that, I'd impose the exact same sentence under 3553, and here's a really detailed explanation of why I think it's warranted under 3553, and in the course of saying that, they say nothing illegal or unconstitutional. Would we really apply harmless error even then? Like, and ignore the fact that the district court said something flagrantly illegal when giving its primary justification for imposing the sentence?
In that instance, if the court relied on facts that it could not rely on, say a defendant's race.
And that even if a district court later said, oh, and by the way, if I wasn't supposed to do the thing I just said, I do this for totally permissibly 3553 reasons, we would still look through that probably, right?
That is true, but we would not apply the Rybicki analysis
But
because.
we're doing, but wait, they're, not to fly spec the question, but there seem to be two moves that are making there. One is to say that if it's an unconstitutional consideration, right, which is the example you gave, that would be one question, right? And I understand you to say, if the judge says, that based on, some guideline provision, I'm going to sentence him to a longer time because he's black, we might not worry too much about harmless error on the back end. Understand that. But I took the question to also encompass, what if there's just like an egregious error? Non-constitutional, but egregious, improper departure provision that has no basis. I take your answer would be different there, because the very nature of sort of a non-binding guidelines means it doesn't matter whether it was like a ridiculous decision or not, as long as it wasn't like unlawful from like a equal protection ground.
That's correct, Your Honor, as long as it wasn't an abuse of discretion.
Yep.
Right, and I take your point. I think that's a good distinction to make between an unconstitutional factor and a factor that maybe doesn't align with a particular departure provision that the court cited. I think we can't get too caught up in which particular departure provision the court cites, because what's important is that it took all of the right factors into consideration.
So
And-
on the, come back to a point that Judge Heitens may have been making earlier here, isn't there, in actuality, a different standard of review for variant sentences than there was under the old departure regime? Under the old departure regime, we were tied very closely to whether there was a specific grounds for departure suggested by the guidelines, and we went through all of that. But under the variant sentencing, it's much more open than departure sentencing, and the district court's discretion is probably at its zenith in a variant sentencing situation. And in a variant sentencing situation, wouldn't we have a greater latitude to look at the any departure in terms of just general reasonableness? And if a sentence is generally a reasonable one, and if it's explained to the point that it's in concrete and that a remand would do no good, isn't it permissible to look ultimately at whether the sentence as a whole, as well as the variation, is consistent with Congress's view in the 3553A factors? I mean, I'm just wondering whether we have a good deal more leeway, and whether district courts have a good deal more leeway and appellate courts have a good deal more leeway in saying, as long as your sentence is reasonable and it squares up with the 3553A factors, we're going to not casually reverse on abuse of discretion grounds. I mean, that seems to me kind of where we're headed in this whole area, gradually, step by step, restoring a greater degree of sentencing discretion in district courts, which is where I think Gall was pointing to in the first place. And there have been some detours in getting to where we are now, but that seems to me kind of where we are with respect to variant sentencing.
Yes, Your Honor, we'd absolutely agree with you. And we would also suggest that that's one of the main reasons why we can tell that Rybicki is no longer good law, because it lays out this 5-step process for district courts to follow when they are going to impose a departure, premised, of course, upon the mandatory guidelines regime. and then lays out 5 standards of review. I guess step 2 doesn't really have a standard of review, so 4 standards of review that are, at least in some ways, different than abuse of discretion. Post Booker, Gall, and Rita, the only standard of review for a district court sentence is abuse of discretion. So Rybicki is absolutely contrary to what we know the law is as it is now. We're only looking at a sentence for abuse of discretion. And here, the district court simply did not abuse its discretion. I've discussed the nature and circumstances of the offense, defendant's history and characteristics. The district court took seriously its obligation to consider all of the 3553A factors. It said that it needed to balance the reality of the horrifying life the defendant had lived and the pain he'd inflicted on so many people, and that it needed to protect society from this individual. There was a dire need to protect society from this individual who's shown himself time and again to be violent, time and again failing to conduct himself in a way that is required by citizens at large. The court also noted the need to deter others who might want to live in the way that this particular defendant had lived, and considered all the other listed 3553A factors, and then imposed its 720-month sentence. I would note,
Is there anything further, Ms. Noakes? Do you have anything further?
if there are no further questions,
Oh,
then-
maybe my colleagues have some further questions. But, yeah, okay. We have no further questions.
thank
so
you. We'd ask you to affirm
Thank you for
the
your
judgment
argument.
of the district court.
Mr. Prescott, you've got some rebuttal time, sir.
Thank you, Your Honor. If the panel's willing to entertain the rebuttal time, I just wanted to focus back on the substantive reasonable and the overall reasonableness and the overall scale of the sentence. The offense conduct and the crimes and the injuries in this conduct are horrific, Your Honor, and we're not here to dispute that. And Mr. Strother specifically told me not to dispute that. But the argument that we're here to make is that not only was the offense conduct extremely severe, the sentence imposed in this case is also stratospherically, unbelievably severe. In this case, where the offense conduct, the specific offense conduct with relation to Deputy Key and Mr. Goff, was heavily considered by the underlying sentencing guidelines range, the district court's Senate substantive reasonableness analysis became unhinged from the appropriate consideration of the guidelines, even after Booker, even after Gall. If these specific facts of the case hadn't been considered as part of Mr. Strother's guidelines range, the recommended sentence would have been 180 to 240 months imprisonment, which actually, I won't go into it, but that aligns closely with very, very closely with the range of sentences typically imposed by the Eastern District of North Carolina in conjunction with crimes involving severe physical injuries to law enforcement. But the district court and the probation office did consider those factors, and instead it enhanced Mr. Strother's guidelines range by at least 11 offense levels, in addition to the statutory maximum, which added about 25 to 30 years alone to his sentence based on what the base guidelines range would have been without consideration of those factors. And then the district court and the government at sentencing recited essentially the same list of factors relating to the severity of the offense conduct, and cited those, again, with no comparison, with no balancing analysis, with no effort to even determine the boundaries of the heartland of the applicable sentencing guidelines, listed essentially the same factors and concluded that they supported an additional sentence enhancement of 15 years imprisonment. And so that's why, Your Honors, we believe that this case is essentially analogous to Nixon from earlier this year, where the compounded procedural errors yielded a guidelines range completely out of step with the circumstances of the case. And just to clarify, our argument isn't that the base guidelines range was calculated incorrectly, but our argument is that the district court's application of the departure clause in Section 3553B1 contradicted the statutory authority for imposing that sentence. It contradicted this court's published mandatory guidance of Rybicki, which hasn't been overruled or undermined in any way that weakens its stare decisis. And as a result, the district court proceeded with a guidelines ballpark that was just way 30 years, 40, 50 years out of line with the normal range of sentences considered by the Eastern District of North Carolina for defendants who are involved in this kind of offense conduct. And it's very possible, Your Honors, that the district court did conclude.
It seems to me hard to find similarly situated individuals, and that doesn't relate solely to the nature of these two offenses, which of course were the most heinous. But the North Carolina rap sheet is pretty formidable. There are just a huge number of offenses over and over and over again. And so you have here the combination of the two instant offenses, and then the history of the North Carolina criminal activity. And so it isn't just lining up when you say, we've got to consider similar offenses. But there are not this many people with two different murderous offenses and a long, extended rap sheet. It really is quite, it almost takes some time to get through it. It's so lengthy. And that makes finding comparable situations more difficult.
That may be true, Your Honor, but our position, we would respectfully argue that the district court is obligated, as this court has held in Moreland and in Nixon and over and over again, the district court was required, the burden was on the district court to provide an extremely compelling justification for this extraordinary departure from the base guidelines range. And it's possible that the facts of this case really did fall outside the heartland of the applicable sentencing guidelines as required by Section 3553B1. But there's no way, we respectfully submit that this court can't determine the extent to which this case compares to the heartland, because the district court was required to compare it to the normal severity, and it never even mentioned the normal severity.
Thank you very much.
Thank you, Your Honor.
Judge Richardson, Judge Height.
I do not.
We have no further questions, and I want to express also the appreciation of the court. So I see that you're court appointed, and you've ably discharged your duties, and we do thank you. We'll adjourn court and come down and say hi to everyone.
This honorable court stands adjourned, signing die. God save the United States and this honorable court.
While I'm at it, I want to thank our fine courtroom deputy for the smooth